it'd be nice to have a quick introduction. We've got 2 minutes, so just quickly a quick hi. If I start with Divesh right from the bottom, Divesh, obviously we're gonna start properly in 2 minutes. But Divesh, why BLUP is so important? Town and Country Plan, BLUP and Local Act. Why is it so important for architect?
Yeah, thank you, Anil, and thank you, everyone. First of all, I would like to thank obviously the speaker, Mr. Phul, and again, Mr. Sinot for making the time for this evening. I think this topic that we've chosen for this evening is really, I would say, a hot topic, because it's long overdue that we had a talk about this topic. So why BLUP? I mean, we've chosen this topic because for a long time there has been debates about the way we plan in Mauritius, really with more power being given to the central government, and then as time went on, it got shifted to a more sort of, I mean, it's still in the process, but the idea is that we become more of a bottom-up. It becomes a bottom-up process. So the BLUP, obviously, we would like to see more power being given to the local authorities to, first of all, make the process more user-friendly, to give the local authorities more authority, if I can use that word, to act, to enforce, but also to be accountable, and also to take account where need be. So that's in a nutshell what I feel about it.
Okay, Divesh, it was supposed to be 2 words, but you've spoken 150 words already on the BLUP. Thank you very much, Divesh. So we're going to kickstart now. It's 6:30 already. So if I can just ask everyone to switch off their videos quickly, apart from Mr. Phul, Mr. Phul, if you can leave your video on for now, and as we do the quick introduction. So thank you everyone for being here, as we welcome more colleagues joining us as well. And I'm just going to share this slide as well. So just making sure we've got everything ready. Can you see my slide, Mr. Phul? You can see my slide, right? Yes. Fantastic. Just making sure. And everyone as well, if you can see my slide, just quick hands up on the emoji quickly, just to validate that you can see my slide and you can hear me properly as well. Thank you very much indeed. Okay, good evening, everyone, and thank you very much indeed for the 4th webinar CBD talk by PAC and MAA. And today's talk is on building and land use permit and the Local Government Act. As Divesh mentioned, it's a very hot topic in Mauritius. It's always a hot topic as well. And we are delighted to welcome Mr. Rajeshwar, Chartered Town Planner. So we'll obviously introduce Mr. Phul shortly as well. Obviously, it's in collaboration with PAC and MAA today, as well as our industry guest speaker, Mr. Rajeshwar Phul, a member of the Royal Town Planning Institute, a chartered town planner. So quick agenda today, we'll have a quick housekeeping as always, introduction, survey, part 1, part 2, part 3, and there'll be question in between with panelists, Mr. Mutana, Mr. Ranjit, as well as Mr. Sinot. Thank you very much. 117 of you have registered today, which is fantastic to see. Also, thanks for all of you for coming today. You will get a certificate attendance. Please email me just after the event when it's finished today with some feedback of how you found the webinar, as well as email me your name for the certificate attendance at anil@cpdtalk.com. And obviously, hopefully it'll be a 1 hour plus CPD. So thank you to Mr. Rajeshwar, Mr. Nalla, Mr. Divesh, Barender, Ramdas, and Raj for giving back the time as always. I'm just going to ask quickly if we can go on menti.com quickly. So if you can start on your laptop or on your mobile, type in menti.com. And I just want to know what your thoughts are to put some context for Mr. Phul in terms of, what are the issues currently we are facing. Again, this is much more of a educational, informative for all of us to learn. So I'm just going to switch to menti.com and just making sure you can see the screen. Here we go. And making sure we've gone live. So again, if you can use the code, if you go to menti.com, type in 72170825. So menti.com, menti.com, and type in the password 72170825. And the question is really, what has been the common issues with building and land use permit, which is the BLUP, commonly known for BLUP in your experience. So again, please, any comment professionally you feel that we can better the system, we can obviously improve the system, or we can adjust the system. So so there's already few colleagues putting in there. So there's delay for approval, we've got discrepancies, someone is saying obsolete, someone is saying outdated, someone is saying administration delay, incompetency, again, okay. There's people having setbacks, cumbersome, okay. Right, so already you can see the keyword there is in blue, which talk about discrepancies. Of course, we've got a few more coming in. So thank you, keep putting them in. And I've got a few seconds before we move on. So I think we've kind of got the information overall that there are, delays as one of the major factor. Lack of information. Again, all of these, Mr. Phul will just touch upon when we go through the questions and things. But also there's another thing about administrative issues as well, which talked about. All right, someone has put new educated blood. All right, so again, that's why we're doing the webinar today. So another one has got a real medal. Okay, all right, so let's move on. I think we've got the gist of it now. Thank you very much indeed. And before we proceed to the next part. So thank you, we've got the gist of it, but keep putting it as we go through. Thank you very much. Just making sure I just swap the screen quickly before we move on. All right. Okay, so thank you very much. Again, so we've got the survey now done. Thank you very much indeed for that. I just want to show a video before I introduce Mr. Phul, Barender and Divesh. And it's quite a poignant video as well, which I want to share with you. So off we go, just making sure I've got the sound ready and the video as well. So here we go. And if you obviously, if you can hear the sound and and you can see the images, please put your hands up. Off we go. Okay, so thank you very much indeed. May I ask quickly to have Barender and Divesh, please, on the Zoom, please, and if you can put your video as well for a quick word on behalf of PSC and MAA. So if I start with Barender quickly, why is so important for this CPD today is so important, and on behalf of the chairperson today, a few words, please.
Thank you, Anil, and thank you to all the participants for being part of this CPD. I think we've been saying that, and we can again repeat that CPDs are very important for professionals to really keep up with their profession and see what's happening, innovations and those kind of things. BLUP and Local Government Act, I think these are, like you just said, hot topics, and the little video that you showed has really given us an idea of what kind of things these regulations and within this framework, what can be done, what can be achieved. So planning is really important. It's like saying if you fail to plan, you plan to fail, right? So I think it's, I'd like to also put in a word for MAA together with PAC that is making all this effort to bring all this knowledge to the professionals.
Okay.
And thank you, of course, to our speakers today.
All right, thank you, Barender. Thank you very much indeed. Divesh, few words from, as the president of MAA, please, few words before we formally introduce Mr. Phul.
So thank you, Anil. Thank you, Barender. Good evening to you all. I am once again very thrilled to welcome you to the second part of our urban planning CPD. We are celebrating World Architecture Day on the 4th of October, and the theme for this year is Clean Environment for a Healthy World. The theme addresses housing, public spaces, and global environmental issues in the wake of the COVID-19 pandemic. First started in 1985 by the UIA, World Architecture Day is celebrated annually on the first Monday of October in parallel with UN World Habitat Day. The MAA, as Barender has just mentioned, in collaboration with the PAC and of course Anil Singh Rana, is pleased to be presenting to you this two-part webinar series. We had a very informative and educational session last week with Mr. Sinot. We are very excited and looking forward to this evening's presentation by Mr. Rajeshwar on the Building and Land Use Permit process and the Local Government Act. We will have panel discussions along the way, so I urge you to please engage and ask as many questions as you can. And we had such a great, session last week with great questions from all of you. So once again, I thank all of you for attending. I hope you enjoy this webinar. Thank you to Mr. Phul, who kindly agreed to give us this presentation. A big thank you to tonight's panelists, and of course to Anil for your usual help. Thank you.
Okay. All right. Thank you very much indeed, Divesh and Barender. Thank you. May I ask to switch off your video again as I introduce Mr. Phul quickly, just making sure we've got everything as well. So just quickly before we go, I just want to share a quick survey as well, where you get the opportunity to vote on the poll. You will see, so if you can see a screen now, are you satisfied with the current BLUP system in place? I know there was comments on Menti, but this now is a more of a yes and a no. Again, something we can just build up as we go through the presentation. So please, if you can just put your vote in, I'll give you about 30 seconds before we get going really. But are you satisfied with the current BLUP process, procedures, the system in place, and the service you're getting? So it's quite interesting to see what's going on in the poll. Mr. Phul, what do you think the poll will say? What do you think? Will it be like a 50-50 or a 40-60? What's your thoughts? Just
mostly no.
Yeah.
Mostly no.
Okay, mostly no. Right, you'll be surprised by looking at the poll as we get through. So I'll give you, what's that, 5 seconds. 80% of you have voted, and I'm just going to now share that with you. And it's quite a surprising poll, I must say. So let me share this with you now, and I'll share the result. And the result saying 41% says they are happy, and 59%, so 60% says they are not so happy. So, all right, something again we can build up on. It's not that bad. So it seems like we have room for improvement, for improving the system. Thank you, everyone. And just making sure we move on. So we've done the speech. Just quickly then, who's Mr. Rajeshwar, member of the Royal Town and Planning Institute, chartered planner, working with the Land Use and Planning Executive in the Ministry of Local Government and Disaster Risk Management. Just quickly, brief history of a summary profile. Mr. Phul is a chartered town planner, currently working at the Land Use Planning Executive at the Ministry of Local Government and Disaster Risk Management. He joined the Ministry of Housing and Land in 1983, then moved to the Municipality of Curepipe as the Deputy Town Surveyor, then Town Surveyor. Mr. Phul was instrumental in creation of planning departments in local authorities in 1995. He was the first planner to be posted at the local government at the time of all planners were in central government. Already we have a bit of history here. And finally, last but not least, Mr. Phul, together with his colleague, Mrs Sunassee, influenced the Business Facilitation Act to standardize procedures in local authorities, notably the BLUP standard procedure for application and setting up the BLUP guide. So please, can you please put your hands up, please, your little emoji to say a big welcome to Mr. Phul today to give back on a Thursday evening. So over to you, Mr. Phul, and I'm just going to stop sharing now. And if you can share your screen, please. And please don't forget to have a quick upload or emoji for Mr. Phul today to give back his knowledge, wisdom as well on this presentation. So we'll just make sure we help out Mr. Phul just to share the screen. And we'll start. And of course, we will stop in between for the panelist discussion as well. Okay, so we're just going to go for the sharing now. And if you can just go again to slideshow and then go for full review. Okay, so just making sure, okay. All right, so if you can just go for the slideshow and then go for full review, it should be all right in a minute. Try to press again on it, please. Yeah, just click on the slideshow again and then go for full review. Yeah, double click on it, double click. It worked before when we started, so.
The mouse is not moving.
Yeah, if you can bring your mouse again, go to the slideshow, just double click.
I mean, I have this bar which is blocking the slideshow view.
Okay, not to worry. Go down your screen, and can you see where notes is on the right? Go four icon on the right. There's that little screen, the little window. Next one. That's one. Yeah, press on that one, and it should be fine. Excellent. Let's go. Fantastic. So thank you, Mr. Phul, and take it away. Thank you again for being here.
Okay. Good evening, everybody. As an introduction, I'll set the context for building and land use permit. So in Mauritius, we have got only two tier level of planning. It is at the central level and the local level. And at the local level, it is the local authorities who are responsible for planning. And local authorities are mostly involved in what we call the development control function. It is one of the most important functions that local authorities perform. And we have got two main components of development control. It is the land use permitting process, what we authorize, and the enforcement part, what action we take against what is not authorized. Now, the philosophy of having a development control is to allow development to happen in an acceptable manner, acceptable to society in general. Over the years, the laws, regulations, guidelines have been prepared, have been reinforced. We have had the creation of planning departments in all local authorities in 1995. In the year 2004, there were two permits which were being issued, but they were merged into a single permit, which is now called the Building and Land Use Permit. In the year 2006, there was a standardization of procedures across all local authorities because at that time, each local authority has its own way of doing things. But in 2006, with the Business Facilitation Act, procedures were standardized, and there was a BLUP guide prepared to help local authorities and members of the public, as well as professionals involved in development, to understand the building land use permit process. There was also the setting up of a committee to look specifically at the permits application. In the past, this was seen at the level of the whole council, but there was a change in the law where the permits and business monitoring committee was set up Subsequently, there were major amendments to the Local Government Act. And finally, there was the creation of a single platform, the National Electronic Licensing System, where people could submit their application for building and land use permit. So compared to 10 years ago, local authorities are now better equipped to deal with the land use permitting process. So that sets the scene for my conclusion. Now I'll go to the nitty-gritty business of the informative part. What do we understand by a building and land use permit? The section 117 of the Local Government Act deals specifically with building and land use permit. So what is a BLUP? Obviously, it is an authorization. It is issued under the Local Government Act. It is issued for carrying out what we call development works on a specific site and according to approved plans. Now, what are development works? Because you need a building and land use permit only if you're carrying out development works. And this is again defined in the Local Government Act. It involves construction works, whether temporary or permanent, erection, extension, or demolition works, making a material change in use of a building, and division of land. It also includes construction on any drain, canal, or any other water course. Now, the law also defines what does not constitute development works. For example, a wall not exceeding 1.8 meters between common boundaries, single-story treillis, pergola, or gazebo, where do we make a BLUP application? It is on the National Electronic Licensing Platform. And all according to the law, which is the Economic Development Board Act, all applications should be submitted and processed online. Applications are usually submitted by a service provider, usually for development exceeding 150 meters square, it is an architect or the draftsman. We have got three types of BLUP application. BLUP 1, it's all residential not exceeding ground plus 3. BLUP 2 concerns subdivision of land. And BLUP 3, all non-residential and all residential above ground plus 3. Now, all non-residential development are categorized in clusters by the Local Government Act. In the Local Government Act, there are 4 clusters: the commercial cluster, the industrial cluster, the service cluster, and the sui generis cluster. Now, not all activities require a building and land use permit. Certain categories are exempted. And this guidance is provided in the planning policy guidance, which Mr. Sinha talked last week, and in the Local Government Act. Now, the guidance provided in the planning policy guidance, the PPG, small-scale enterprises carried out in the home without modification of the dwelling, but subject to conditions. So somebody can use part of his home to carry out an activity, and this activity can be exempted from a building and land use permit application, but subject to certain conditions. There should be limited movement of vehicles. The activity should not give rise to noise, dust, fumes, vibration. The operator should normally reside at the premises. I cannot rent somebody's room to do an activity. And there should be safe storage of materials. This is the guidance provided in PPG. Now, the guidance provided in the Local Government Act, subject to the above four criteria I mentioned, if there is a change of use within the same cluster, commercial to commercial, industrial to industrial, service to service, you don't require a BLUP, provided you respect the four above criteria. But if you fall in the sui generis cluster, for any change within that cluster, you would be requiring a building and land use permit. Now, processing of applications. Applications have to be in accordance with relevant enactments and guidelines. Usually it is the Town and Country Planning Act, the Planning and Development Act, the PPG, the Environment Protection Act, the Building Control Act, etc., and guidelines issued under these acts. All applications are determined, they are examined and determined by the Permits and Business Monitoring Committee, PBMC. The law provides that the committee may request an applicant to attend a meeting to give more clarification to his application. And the minister responsible for local government has a droit de regard on any decisions of the PBMC or recommendation of the committee. And the minister may determine an application where necessary or expedient in the public interest. It means that the minister has a call-in power. He can call in an application and determine that application, but it should be necessary and expedient in the public interest. And so far, the minister has not had resort to this call-in power. Now, the law defines crucial dates for the processing of application. When you submit an application online, you should be issued with an acknowledgement receipt. Within 8 working days of your submission, the local authority may request additional information, documents, and particulars. Once the local authority is satisfied that it has received all the required information, documents, and particulars, it will give an effective date to your application. Now, once an effective date is given to that application, the local authority is duty bound to determine that application within 14 working days as from the effective date. That is, either approve the application or reject the application. Now, if within 2 working days of the expiry of the due date being the 14th working day, you have not received a determination, you have not received either your BLUP or you have not received a rejection, then the silent agreement prevails. Now, what happens if application is rejected? Before that, I'd like to add that not all applications are given effective date. There are certain exceptions. For example, for places of worship, the application has to be approved upon recommendation of the local authority by the minister. So for this type of application, there's no effective date and there's no silent agreement. Now, what happens if the application is rejected? Applicants have a right to appeal to the Environment and Land Use Appeal Tribunal. And the Supreme Court has ruled out that only an applicant can appeal to the tribunal. Other aggrieved parties, they have to seek redress from the Supreme Court. So this has been ruled out by the Supreme Court according to what is provided in the law. Of course, we are conscious of this, and in any future amendments of the Local Government Act, we are going to redress these situations. Now, what happens after the issue of a building and land use permit? You have got certain obligations. If you don't act upon your building and land use permit, it will lapse within 2 years. There's an obligation to construct, develop according to approved plans. There's an obligation to obtain an occupation certificate, and where buildings exceed or of an area of 150 meters square or above, a certificate from the principal agent is required, certifying that the building has been put up or the development has been carried out as per approved plans. And this occupation certificate needs to be obtained prior to occupying the building. Otherwise, it's a contravention and legal action can be taken by the local authority. And if you're carrying out an economic activity, once you have been issued with a building and land use permit, you have got an obligation to pay a trade fee where required within 15 days from the start of activities. So that's the end of part 1.
Okay, thank you, Mr. Phul. Just quickly then, I'm just going to stop sharing now and just get some of the question. Okay, so just going to stop share here. Thank you very much indeed. There's a lot of questions coming as well. So I'll just take the question. I know Mr. Joy has sent a few questions as well. And can I ask Mr. Mutana and Mr. Sinod and Mr. Raj to join in as well as part of the discussion, please. If you can put your video as well, and Mr. Sinod, if you can put your video on as well. So there's quite a few questions coming up, and it's in the first time in history we had so many questions in part 1, and rightly so, I guess. There's a question for you, Mr. Phul. It's to do with when will OPP application be online? I mean, what's OPP? I don't know what's OPP.
And OPP, it's an outline planning permission.
Yeah.
So it's a provision in the law. You can apply for that permission if you want to gauge the local authorities' feeling whether a development may be acceptable or not in principle before engaging yourself in full plans of the development. So it saves costs, it saves expenses and energies. But it's not actually online, but measures are being taken to have it online.
Okay, thank you very much indeed. The next question is has BLUP application for building above 150 meters square necessarily be submitted by the architect? If not, can't we make it mandatory?
The law, I think the Professional Architects Council Act provides that the plans have to be designed by a professional architect. But who submits an application? Previously it was for buildings exceeding 150 meters square, it was by an architect. But since now that every application for BLUP has to be online, I suppose anybody can make an application, submit an application, not necessarily an architect.
Okay, so Mr. Mutana, do you have anything to say on this in terms of the 150 meter square? What's your thought on that to make it mandatory?
First of all, thank you, Mr. Phul, for this very, very clear presentation. This 150 meter square limit is very important because previously it was 400 meters square that has been reduced to 250 meters square limit to be designed by an architect. And now it's 150 meters square. Why 150 meters square? Because nowadays, any building, any construction of more than 150 meters square would cost you a few millions of rupees. And if you're investing so much, I think it's in your interest to have a building that is designed by a professional, not only just for the savings, but for your own safety, for a better design, for a plus value after having done your project. So this has been understood by the authorities concerned, that all buildings exceeding 150 meters square needs to be designed by an architect. This is in the interest of the public, because 150 meters square, it's costing nowadays about 4 to 5, 6 million rupees, depending on the type of finishes. So if you can afford 5, 6 million rupees, so it's better for you to have it designed by a professional.
Absolutely, absolutely. Thank you, Mr. Mutana. Just quickly, then we'll take some other question. That's again for Mr. Pearl. How can we prevent LAs to buy time in the processing of an application by asking for missing document already provided? So how can we try to mitigate local authority to buy time in process application? I mean, we saw that in the M.R.T.P.I as well. What's your thought on that, Mr. Pearl?
We always advise that prior to for major applications, it's always good to have a pre-application meeting with the planner at the local authority to sort out everything before submitting your application, so that you make sure that when you submit your application, you won't waste time on answering to further requests for further particulars, etc. Plus, you have to make sure that what documents are required are submitted and the right documents are submitted. A complete document is submitted. Very often, we get, when we request for title deeds, we've got pages missing. So it's a matter of checking you are submitting a complete set of documents, the right documents. They are, you can read that they are readable when you submit. And you should have a consultation with the local authority officers, the right person. Many persons get information from any Tom, Dick, Harry they meet in the front office, but they should try to meet the right person, and they should insist on meeting the right person, and they should know their rights that are in the law.
And presumably, Raj, in terms of, is it really buying time? Or is it public sector trying to adhere to the process and protocol?
First of all, hi everybody, and thank you, Mr. Phul, for this presentation. I'll retain something that we must meet the planner. It's not easy for an architect for each and every project to go and take an appointment, to wait over there, to meet the planner. And most of the time, it's not easy to meet the planner. You know very well how busy you are, Mr. Phul. And the other planners are as busy as you. And if each and every architect, we are 250 architects in Mauritius practicing actually, and if for each and every project we have to go and meet a planner, it will be very tough for you, for you all in the municipality and the district council. And that's what I wanted to say, Anil and Mr. Phul.
Okay.
Can I react to that?
Yes, please.
I'd like to react. I said for major applications. I specified for major applications. I have worked in a few local authorities, and each time an architect, nobody is going to deny that to me, that they have sought an appointment. I have always been available, not even for architects, but everybody who. So you should know your rights and you should insist.
Okay. There's another great question. We'll come back to Mr. Sinat shortly. And the question is really, why are BLUP granted classified as confidential? So why BLUP are classified as confidential?
This is again one of the odd things in the Local Government Act we are trying to redress, because we'll be having some amendments in the Local Government Act, and this is one of the things we are looking at.
Okay, thank you. Mr. Sinha, just quickly, before I take another question, which is very interesting, what's your thought on the BLUP process? Having been in the public sector now, working for private sector, what's your few, what few comments you may have on BLUP from what you've heard right now?
Yeah. Thank you. Hi, everybody, and thank you very much for giving me this opportunity in the panel. So really, it's quite very hard for because we are a major developer in the area, and with much difficulty we managed to get some appointments. To be honest, I've been at the local authority, at the City Council, quite often. I see they are very busy. The inspectors are very busy. They are overladen with so much work, but maybe some more resources are required. And talking about Mr. Phul, who has done a very good presentation, which is very clear. We're talking about standardization of procedures. In my opinion, I think that there's no standardization of determining the applications. Maybe the same application, if it was determined by another head planner or planner, you would have seen it in a different way. So at times, the system, the NERS system is quite rigid. This is a major problem. The NERS system is quite rigid, so you're given only a last chance to upload your additional information that is required. And once they don't accept the additional information, there is something missing. So your application is rejected. You have to go back to square zero, put the notification and so on again. So it's a very lengthy procedure. Mostly when development, we need development in this country. We need development, and we see that major projects at times everything is ready to start it up. We just need a last tick of the permit to start the project.
Okay.
There's much needed. Yeah.
Okay, thank you, Mr. Sinha. Just quickly then, Mr. Phul, there's another question for you. Should the clearance certificate not be issued by the architect, even if he does not supervise the construction, to ensure that his project is not modified without his consent? So the question again is, should the clearance certificate not be issued by the architect, even if he does not supervise the construction of the project?
The law states principal agent, but then I'd like Mr. Mutana to reply to that, please.
So thank you. So the principal agent, it could be either the engineer or it could be either an architect, depending on the type of project you're working. So it's very important that the person who is the principal agent, the one who is in charge of the project, he is the one to come and give this clearance certificate. What is the clearance certificate? Is that that person at the end of the construction, he will have to come and check the as built, whether the building has been built as per approved plans. That's his only job. He comes and check and gives a certificate that the building has been constructed as per the approved plan, and then sends it to the local authorities, and they come back within a week. They give you your occupation certificate. This is how it's done. So if there are any change when you come and do this clearance certificate, then you have to apply for an amendment and get that approved.
Okay. All right. Thank you. Raj, do you want to say anything on the clearance certificate, or is it all clear there? Do you want to have any?
It's clear. It's clear. It's clear. Mr. Mutana has well defined everything, and yeah, good.
Okay. Thank you. So just quick one, Mr. Phul. There was a question from a colleague of mine who was unable to attend today. He said, when you apply for your BLUP online, is it not supposed to be the architect only? Or as you say, it could be any Tom, Dick and Harry to apply. So why is it not the architect to put their registration number there, and the architect has the right to apply?
It is the service provider because not all plans are drawn by architects.
Whoa, okay. Okay, so Mr. Mutana, what's your thought on that?
So what Mr. Phul meant is all buildings below 150 meter square, it's not mandatory that these buildings need to be designed by architect.
So I can just go on BLUP and apply. If I'm not an architect, so I can just go on BLUP and apply for below 150.
Yes, for all projects below 150 meter square can be designed by a draftsman. That's no problem. That's the law. But all buildings above 150 meters square will need to be designed and signed by an architect.
Is that why we have the option of anyone can apply?
Most probably, yes. But with the previous system, there was a system earlier that started with the local government, not the NELS one. At that time, only architects and engineers were authorized to register with the local authorities online. And once you are registered, it was only architects or engineers that could apply for BLUP. So with the coming of a more user-friendly system done by the NELS, right, by the EDB.
That's right, yeah.
So now anyone can apply. It could be an architect, it could be the client himself. Once the client has got all the necessary drawings and he's got all the documents, so the client can apply directly online and pay the necessary fee at the time of issuing the BLUP. Yeah.
Okay, thank you very much indeed. There's a question from Sebastian, Mr. Phul. In the past, authorities have required details for boundary wall of 1.8 meters for approval. Contrary to what you have mentioned, can you please expand a bit on that, please? Are boundary wall fences allowed to be more than 1.8 meters?
What the law says is if a boundary wall of up to 1.8 meter high between a common boundary, it is exempted from a building and land use permit. But if it is above 1.8 meter, you should apply for a building and land use permit, and along an access, irrespective of the height, you have to apply for a building and land use permit.
Okay, thank you very much indeed. He also goes on to say, could you please expand a bit on temporary structure? What about chapiteau type structure?
There is a definition in the law, a structure for holding a trade fair, etc. They are exempted.
Okay. Raj, do you have anything to say on this one?
Yeah, maybe how can it be exempted when it receives public more than 100% under chapiteau? I think maybe we should review in the future this kind of authorization. You know, when you have people, you are receiving people in a fair, you know, in a more than 50, 75, 100%. And there must be an authorization, I think, because it's quite heavy, this structure. And if ever there's big wind or there's a malfaçon, as we say, it can be dangerous.
Okay.
Yes, but then defining temporary structure has proved to be problematic because there was an issue long time back when there was that the Ganesh Chaturthi festival, a Ganesh Murti had collapsed and the police had inquired, should not have this structure be given a BLUP.
Wow.
But then the law says movable or immovable. And the other question which was raised, when there is that pilgrimage for Mahashivratri, we have got all these movable structures. So we were treading on very sensitive issues and difficult grounds, and it has remained at that point.
Okay, thank you. We'll take two more questions before we move to part 2 of the presentation. There's a question there, Mr. Mutana, for you. Is it mandatory for an architect to be CIDB registered to submit a BLUP?
Well, it is mandatory for a firm of architects to be registered with CIDB to be able to practice, a firm of architects. But if you are an individual architect, it's not mandatory that you have to register with the CIDB. In fact, it's not even a requirement for individual architects to be required with CIDB. It can come in the future, but now, in this point in time, no, you don't have to register.
Okay, thank you very much indeed. There's a question from a student, Mr. Phul. I'm an architect student here. Could you please explain the terms sui generis and perhaps use example for clarity? I mean, just a few words on that.
Sui generis is what does not fall, it's a category on its own. For example, let's take a stone crushing plant. It will fall in the sui generis cluster. Now, if you want to change from a stone crushing plant, you have another extractive industry. It doesn't mean that because you're in the same cluster, you'll be exempted. So all these difficult industries, these sensitive, bad neighbor users, they are put in the sui generis cluster so that you don't get benefit from this automatic exemption. Each time you change activity, you have to apply for a BLUP.
All right, thank you. We'll take the last question, and obviously there's plenty of more which we'll tackle later on. Mr. Sunassee, there's a question for you. Don't know if you can answer this one. It's an anonymous attendee. He or she says, can you please clarify if the regulation of the municipalities and district council of Mauritius differ from each other? Because it seems so. So there's one regulation for municipalities and there's other for district council. What's your experience on when it comes to town and country planning?
To be honest, I've not been involved so much in municipalities. I've just moved to the rural local authority. But municipalities, maybe because of the towns, they have a different, the uses are different, the mode of development is different than in rural areas. So, in my opinion, there should not be a different set of rules and regulations. They should be standardized, but depending on the type of development that is proposed. Because now, many areas in villages, you have the village centers, which like if you go to some village centers, they're just like towns. So, in my opinion, the same rules and regulations should be applied, and there should be the guidelines should be on basis of the type of development and the surrounding uses.
In fact, the village centers are bigger than the town. So, yeah. So just quick one then, Mr. Phul, what's your thought on that in terms of the difference between the municipalities and the council?
There's only one local government act governing all local authorities. What is specific to the councils is their boundaries, but they are governed by the same set of procedures. And what is different, each local authority has its own outline planning scheme. So that's what differs. Otherwise, regarding legislations, each council make its own regulations, but specific to, let's say, waste collection of rates, etc. But otherwise, most of the things are common to all local authorities.
All right, Mr. Mutana, please.
Yes, before we move on to the next topic, I have a few comments to make on the BLUP. First of all, Mr. Phul spoke about the time frame to request additional information, which is 8 days. So I would like to know what happened when the requests come after this limit. Are we obliged to attend to these requests? Do we have to reply to these requests, Mr. Phul?
It's a request for information, documents or particulars. So, yeah. I mean, if you are receiving this, No, the local authority has 8 days to request you further clarifications. Now, but then you're given 4 weeks to submit same. And obviously you have to submit this in order for your application to be further processed.
No. This is not what I meant. Once you do your application online, right? You have submitted all your documents. So as per the BLUP conditions, the local authorities have got a maximum of 8 days to request any additional information if they do require additional information. So what happens is if they don't ask you within that 8 days and they ask you after 10, 12, 14 days. So are you obliged to abide and to give them this information?
No.
I will explain it. Yeah.
That's why I said you should know your rights.
Yeah.
It's only 8 working days. Within these 8 working days, they should, if they don't request any information, it means that they should give an effective date to your application. And the effective date is the submission date.
Yeah.
And they have to determine your application within 14 working days.
No, this is clear. This is
And
very
they cannot reject your application because they lack further particulars or information. They cannot use that reason.
Okay. So that's fine. So now after the 14 days from the effective date, say we have not received any reply from the local authorities, can the construction start on site?
It cannot start. You have to claim that silent agreement first. You have to pay your building and land use permit fees. And the law says that your acknowledgement receipt and the receipt for the building and land use permit fees are deemed to be your building and land use permit.
So is there a special process for this?
There's no special process. You have to go and prevail yourself of this silent agreement at the local authority.
Okay, it's not that simple. So I will give you a personal experience. I did receive a request for additional information after the 8 days. In fact, I didn't receive after 8 days. I was asked additional information after 14 days, and it was from the Municipal Council of Curepipe. And the guy phoned me. First, he phoned me, he said, we need additional information. So I said, no, I can't give you any additional information. It's already 14 days now. I'm not supposed to give you any information. And my client has already started the work on site. So the next day I was issued the permit. He did.
The next day you were issued what, Mr. Mutana?
The BLUP.
Okay.
Yeah.
All right. Okay. So again, it's a lesson learned there for us. Just a quick one then, before we go for part 2. Mr. Phul, you talk about silent agreement. There was a question there from Ashwin. What is a silent agreement?
A silent agreement, the law provides that your application should be determined, that there is a decision taken to give your permit or to reject your application within 14 working days as from the effective date. Now, if you don't receive a reply on the 14th day, then after the 14th day, there will be a deemed approval of your application.
Okay. All right. Thank you. I think that's clear for all of us. Thank you.
A small suggestion to Mr. Phul and to the local authorities. You know, a project that has obtained an EIA, does it have to follow the same process? What I mean is, hasn't the local authority already given its approval, and why can't it go on a fast track in view of business facilitation and costs involved? How do they proceed for a project that has already got the EIA? Which means
there are certain conditions in the EIA that may require further clearances.
Yeah.
So it depends on the project. For example, they
No, this
may
is
require
fine.
you to submit a clearance from the forestry services on application for BLUP. So it depends on the conditions of the EIA.
Okay,
No, this is very good.
Mr.
I mean,
Mutalan, let's take the
the
question at the end. Let's move on to part 2 of the presentation. Thank you everyone so far. We've got a record number of 24 questions already. It seems like we'll be here till midnight. But of course, obviously we've got limited time. Mr. Pearl, take it away. So can I ask the panelists to switch off the video, please? And Mr. Pearl to share screen again. So if we can share screen for part 2. But please put your question and comments in, as we are truly, enriching ourselves with all the issues that Mr. Pearl are sharing with us right now. Obviously, your question can be seen as well. We can see your screen now for end of part 1. Please proceed with Mr. Part 2, Mr. Pearl. And thank you on behalf of everybody watching today and on behalf of PAC and MAA. Thank you. Yeah, and then just go next on that one. Fantastic. Thank you very much.
So what happens when you submit your applications for BLUP at the local authority? And I'm talking about an ideal situation. It may be true to a certain extent for certain local authorities. So there are 5 important steps that a local authority should be involved in: advising applicants, receiving application, assessing application, determining application, and notification of determination. So when very often advice is sought from the planning department before submitting an application. The advice may be of a general nature or of a technical nature. So depending on the type and scale of development, technical advice should be given by inspectors and planners and not by junior staff. And it is expected that all the staff of a planning department should be able to give advice of a general nature. When is a BLUP required? What are the usual documents that would be required? What is exempt development? That is, in which cases you don't require a BLUP. How and where can one make an application? How long does the process take? And what are the payments that have to be effected? At the local authority, inspectors who are at the mid-management level, they should be aware of what are the clearances that are usually required. When is a land conversion permit, an EIA license, or an M.R.T.P.I required? And what are the notification procedures? When are you really required to do a notification of your development? Now, once you have submitted your application, there are various levels of verifiers. The first level of verifier, they will verify whether the application has been made on the correct form, BLUP 1, 2, or 3. All the relevant parts of the form have been accurately filled in. For example, the title deed reference are correct. The applicant's name is correctly written as it appears in the national identity card and in the title deeds. The proposed development is properly described. Just saying that residential development is too vague. You have to describe the number of floors, etc. The location of development is clear. You just cannot say it's in Plain Williams or it's Curepipe. You have to be accurate. Give a number if you have got a number. Give the name of the street correctly. The contact details of applicants are clearly shown. The required documents have been uploaded in the relevant slots. The documents submitted are relevant to the development. For example, it may happen that we receive a title deed, but which is not for the site which is being developed. And where required, notification procedures have been complied with, and the relevant documents submitted. I wish to point out that there are mandatory delays for requesting modifications, like I explained, within 8 working days from the receipt of the application. Now, the second level verifiers, which are the inspectors, they will ensure that checks have been carried out and that all required clearances have been received. You will be requested to submit your clearance where required. You will be prompted on the system to send your application to the CB, to the CWA or WMA. There are a few questions you will have to answer and the system will send it. And if for 2 public utilities at least, CB and CWA, and the Wastewater Management Authority, if there is no reply, there is a deemed approval after 5 working days. Now, the inspectors will assess applications with respect to the outline planning scheme, the planning policy guidance, the building laws and regulations, and other applicable legislations. For example, the environmental guidelines issued by the Ministry of Environment. They will have to locate the development on the relevant development management map of the outline planning scheme. Once they locate that development on the development management map, they will be referred to the policies which are applicable, and they will have to see what the policies say. Now, for a major or complex application, a site visit is desirable. They will effect a site visit and they will record the date and observation in the application. And prior to making a recommendation on the application, they will want to discuss it with a planner or somebody senior to them. It is not the case that the head may always accept an inspector's recommendation if that recommendation has not been properly substantiated. Now, the head is the final verifier, the head or the assistant. They will review the assistant by the recommendation made by the inspector, that is the second verifier. They will confirm whether further clarification should be requested. In case no further clarifications required, they will decide to give an effective date and they will submit the application to the public. If an effective date is given, they will submit the application to the PBMC with their recommendation. But here again, the attention of heads are always drawn to the fact that their recommendations may be challenged in an appeal tribunal or a court of law, and therefore for the assessment to be defendable, the recommendation should be objective and based on factual documents, that is policies, laws, guidelines, etc. Now, determining the application, it is only the Permits and Business Monitoring Committee, except for the exceptions provided in law, that is those places of worship where the Minister of Local Government approves an application. Except for those, it is only the Permits and Business Monitoring Committee which is empowered to determine an application. The PBMC may not go along the recommendation of the officer. They might overrule the recommendation of the officer, but their attention will be drawn to the risk that any decision which they take which is contrary to law will not be defendable in law. Now, where an application is refused, the decision should be based on planning grounds and policies drawn from the outline planning scheme and PPG and other relevant legislations. It should be planning and it should not be any whims and caprices of anybody. Now, there is a notification of determination. as soon as the PBNC has taken a decision on an application, the applicant should be notified of the decision. Either the BLUP is issued or it is issued with the conditions that have been decided by the PBNC, or the refusal letter is issued. It is important that the grounds of refusal are properly drafted and reflect the decision of the PBNC. I know that members of public have a lot of critics on this because not most of the time, certain grounds of refusals are not properly drafted. So that brings me to the end of the part 2.
Okay, thank you very much indeed. Let me zoom. I just want to make sure we've got that right in terms of, just bear with us. Again, if I can ask the panelists to put the videos in quickly, thank you. And also, can we have a big round of applause for Mr. Phul, please? If you can put your little emoji. Already there's lots of wisdom being shared by Mr. Phul right now, and it's fantastic to get all this inside knowledge. So once again, thank you very much indeed, Mr. Phul. I think Mr. Mutana, if you can put your video as well. So just quickly, I just want to cover on the part 2 of the presentation. Raj, what was the point or the most important one from your perspective? I know we've got lots of questions. I want to take this at the end because I want to get all the questions answered. But what was your key moment on the part 2 presentation?
Anil, I've missed part of it. I have a problem with the unstable internet.
Yeah.
Even sometimes it is being freeze, you know. I have a little problem with the. Maybe you'll pause the answer to Ramdas, who has already been.
Let me just go with Mr. Sinod. Anything that you picked up on part 2? Anything that you need to share with us, Mr. Sinod?
Yeah, thank you, Anil. I have one question I would like to get clarified from Mr. Rajeshwar is regarding clearances sought from other authorities. So what I understand is that when we submit an application for building and use permit, the local authority will either itself seek the necessary clearance from the CB, CW, and maybe LD. But at times they ask the applicant to go and seek these clearances. Now it's a lengthy procedure for the applicant to go and get these clearances, and these authorities, they have their own priorities. They may take that much time. Does a clock stop at this point when you're asked to go and seek the clearances once you get these clearances? Or suppose you're asked to go and seek the clearance from the forestry department. So, and now the forestry department takes all its time to give you the clearance. Is it something that, is there any way to force the forestry service to come into the system and to give its clearances within a certain limit? So this point I would like to clarify from
Mr. Phul?
Well, the system does not provide for the applicant to go and seek clearance. It's at the time you're submitting your application, you will be prompted whether or not to send your application. For example, for the CB, they will ask you whether you are in an approved Morcellement, your development is complying with certain criteria. Based on the answer you provide, then your application will automatically be transmitted to the CB, and regulations have been made under the Local Government Act for 3 public utilities, CB, CWA, wastewater management, where if they don't answer within 5 working days, it is a deemed approval. So I don't get your point about going to seek clearances, but what the sort of clearances that you might be seeking, and it's not usually the applicant, but it is the local authority. For example, if you have an access on a classified road, you need the clearance of the RDA. And in this case, the local authority will send your application to the RDA, and there the clock stops and the process is put on hold.
No, but for example, I have one application where in additional information we have been requested to go and seek clearance. Suppose our proposed development is close to full reform. to have been asked to go and seek clearance from the veterinary services of the Ministry of Agro-Industry. There's according to their plan, there's an alignment of a water course, which now doesn't exist, but according to the plans it existed. So we have to go and seek the clearance of the forestry service. We are asked, we are prompted in the system, in the additional information required from us, we are asked to go and seek these clearances. So now when we go to seek them, we have no guarantee that within our time limit, we'll be able to get these clearances.
Okay.
But then you should ask, like I said, you should know what are your rights. You should insist for your rights. And if you are being asked to seek for a clearance, you should know why. And if they are, for example, if they are requesting you to seek a clearance from the forestry services, are you building within the river reserve? I know that nobody is allowed. So if you have clearly shown your river and your reserve, and you're outside that reserve, there's no reason why you should be seeking the clearance of the forestry services. If you have you're not creating an access on a classified road, you don't have to seek the clearance of the RDA. Now the TMRSU has submitted its guidelines in which cases applications have to be referred to the TMRSU, and it is clear, not in all cases, for certain floor area, etc. So local authorities, you should insist for your rights, and you should insist for your right to know why.
Okay. All right. Let's I want to just hear from Mr. Mutana on part 2. I'll take 2 questions, and then we'll do part 3 and take all the questions, because there's so many important questions which we'd like to take and really answer all of them before we conclude. Mr. Mutana, in terms of part 2, anything that you want to share your wisdom with, or anything, your thoughts on part 2?
Well, normally what Mr. Phul has just explained, it's all about the internal procedures that are being adopted at the local authorities. But I would like to just to add on what Mr. Sinat mentioned. I would give a personal experience. I did submit an application for a project whereby it was built near a river, and it was on a road or something, right? Whereby we needed to have the clearance of the TMRSU, and that part near the river, we had to get the clearance of the forestry department. But I would like to underline that all these clearances, we didn't have to apply for it, because once we submitted our application online, it was the local authorities themselves that forwarded to the agro industry, right, and to the TMRSU to get their approval prior to giving us the clearances. But it's true, in these particular cases, it takes more than 5 days, Mr. Phul, you will agree with me. But most of the time, they do it within a proper time frame. For example, the TMRSU, they will have their meetings every weekly or every fortnightly. So by the time they receive your application to give you your clearance, you might be waiting for a month. So these are things that happen. But what I would like to press upon is, this is not done by us. This is done directly by the local authorities who forward your clearances directly to these necessary ministries. Yeah, that's how it is.
Thank you, Mr. Mutana. I've got 2 questions relevant to part 2, and then we'll move on to part 3, and then make sure we take all the questions there. Mr. Paul, there's a question there. Can PBMC intervene in the determining process of the planner? Cases where political lobbying have forced planners to grant permit. What's your thought on that quickly?
A planner is a professional person. He has to submit his professional advice to the PBMC.
Yeah.
He has to convince the PBMC, but if the PBMC is not convinced, he cannot do anything. As long as his recommendations and advice are properly recorded, and inserted in the minutes of proceeding, that should be fine, because he does not have a say on what will be eventually decided, because the PBMC is made of a majority of councillors, and if they decide to approve an application, whatever recommendation has been made, they will approve it. But it depends on your relationship with the PBMC and your professional commitment to your decision-making, recommendation, etc.
Absolutely. Okay, thank you very much indeed for that one. And lastly, there's a common question going on. Where do we find the TRMSU guidelines? So where do we get the guidelines for TRMSU?
All local authorities have been issued with these guidelines. They are aware. We have got some amendments we are making on the system, and as soon as it's possible, we'll put up these amendments on the system so that every applicant will have access to these guidelines. Okay,
thank you. Raj, you want to say something?
Yeah, Anil, I wanted to add, Mr. Phul just said it. It is important to have all these guidelines easily available, because not everybody have access to these guidelines. Maybe it must be on a special site of each and every municipality and local government to have the guidelines, the act, the town, everything, so that when we go for an application, there is one-stop shop for everything.
Okay.
Yeah.
All right. Thank you very much indeed. While we've got a question quickly as we move on to the last part of the presentation. And the question is really, the BLUP application process has undergone significant improvement recently. Obviously, Mr. Phul and team and everybody else is making sure that they make the process as seamlessly as possible. The question is, do you find the process more user-friendly, or is there room for improvement? So it'd be great to have your comments there. I think by mistake I've got choice free, but it's only those two questions there. Do you find the process more user-friendly, or is there room for improvement? I mean, Mutana, just quickly, Mr. Mutana, just quickly, what's your thought? Do you think there's a room for, I mean, there's always room for improvement, but are we happy with the current system?
Yeah, I mean, exactly, there is room for improvement. I'll just give you one simple example. When you apply online, when they ask you for additional information, it's very easy, it's very simple. You have to upload additional drawings. This is done within a few clicks, right? But there is a problem when there's a change in the name. Say, for example, you have done your application under the name of the applicant, which is a company or something.
Yeah.
And the municipality asks you, you know, the owner of the land is on the name of one of the director. So you have to change the name of the applicant. So in fact, you can't change the name of the applicant in the system. You have to duplicate your application and then resubmit everything. So which is I think this is something that they can improve upon. Otherwise, as regards using this NEL system, is quite user friendly. Yeah.
Yeah, Mr. Phul, any comments on that? Maybe something we can improve. What do you think?
Only this morning we had a meeting with all local authorities, planners, and chief executives, and the EDB, and we are setting up a team at the ministry to look at all the improvements and what Mr. Mutana highlighted. We are looking at the possibility of making this field editable so that anybody can edit. We are improving on the system. It is relatively new. All local authorities went online in 2019. So it is relatively new. Now we are working on the improvements. We have already carried out 41 improvements on the system so far. And we are setting up a team to carry further improvements. What I would like to propose, if the PAC has certain improvements to make or suggestions, they can always write to the ministry on behalf of the PAC, and surely we'll take good note of this.
Okay, so I'm just going to share the result quickly.
Sorry, Anil. maybe you could ask the chairman of the PAC or the president of the MA to join one of your meeting to share in your meeting what are the problems that we are facing actually. Like Mr. Mustana said, even for the TV number, if it is not the wrong TV number, everything is rejected. You must start a fresh upload everything again, you know. And I know it was designed maybe by PwC or another company, and it can still be improved, and maybe some meetings with the architect, with the user is important.
Okay.
Voila.
Thank you, Mr. Raj. Just quickly then, as you can see the poll there, 11% says yes, it is user-friendly, but of course, there's always room for improvement, and 89% says, of course, there's improvement. So thank you for that. And just Mr. Jai Soredu, who is currently with the chairperson or chairman of PSC, he's watching us from France, and he mentioned a very good point. Mr. Jai say, I must say that we are even further ahead of France, where permits are still being submitted on paper. So Mauritius is ahead in terms of online application, which is fantastic for our country. So already some good news there, some positive news. So thank you very much indeed. Mr. Pearl, can you take please part 3, and then we'll take all the questions before we conclude. So can I ask the participant to please switch off their video, please, and mute yourself as we move on to part 3 of the webinar. And then obviously we'll take that up ahead. So, and I think Mr. J say as well, the NEL system is a great step ahead. So, which is a great milestone for our country. Please proceed with part 3, Mr. Paul. Thank you. If you just click on the slide and then go next, you should be fine. Yeah. Anywhere on the slide. Yeah. Awesome. Perfect.
So the part 3 will be all about enforcement. In 2018, there was an amendment to the Local Government Act. The enforcement provisions were dispersed in various legislations, and this amendment brought all enforcement provisions under a single legislation, the Local Government Act. So prior to 2018, you could take action under the Town and Country Planning Act, under the Building Control Act, or the Local Government Act, but the Local Government Act brought all the enforcement provisions under a single act. Now, these new provisions, according to the law, they apply only to development works undertaken on or after the commencement of the Amendment Act. It means that what I'm going to talk about, it applies to only unlawful development taking place after 2018, October, I think October, November 2018. There are 3 types of notices that can be served under these enforcement provisions: the compliance notice, the enforcement notice, or the pulling down notice. The format of notices are, according to law, they should be in forms as prescribed, and the ministry has prescribed these forms. So any member of the public not getting a notice under the prescribed form should be aware that that notice is not in order. And local authorities are bound to use the prescribed forms, and they cannot make any amendments on their own. Now, how do we serve a notice? It is either personal service, through registered post, or through what the law describes as substituted service, that is affixing notice at the last known residence or business address and where development works are being undertaken. Now, for pulling down notices, there are additional provisions. You have to make publications in 2 daily newspapers, one after the other, and the second notice not later than 15 days after the first one. In case you have complied with the notices, the law provides that notices remain in force unless they are specifically revoked, and it is only the chief executive of a local authority that has the power to revoke a notice, and a notice is revoked once the requirement of the notice has been complied with. That is, any action that you were required to take has been taken within the specified time, and the person is informed of the revocation through writing. Now, if you have given, usually you're given 30 days to comply with certain requirements, but in notice, the time can be extended up to 60 days by the chief executive, and the chief executive has to show good cause for extending the delay. Now, a compliance notice, coming to the notices, a compliance notice is issued for development works where you don't have a building and land use permit. The notice will ask you to apply for a building and land use permit within a delay of 30 days. And if you do apply for a building and land use permit, and if that permit is approved, you won't get your permit until and unless you pay a penalty fee of 50,000. You have got a delay of 28 days to pay that penalty fee. Otherwise, the approval of the BLUP will lapse and you will be issued with a pulling down notice. And enforcement is issued where a person is in possession of a building and land use permit, but that person is not developing in accordance with the approved plans. And the enforcement notice should specify the conditions which have not been complied with and the measures that have to be implemented, and the delay not exceeding 30 days to implement these measures. Where the holder of the BLUP fails to comply with an enforcement notice, the BLUP shall be revoked. That's what the law says. A pulling down notice is issued for development works where you don't have a BLUP. You were given a chance to apply, but you didn't apply. Or you're carrying out works on canal or river or drain or any without permission or a water course. And a pulling down notice should specify the nature of works and the delay not exceeding 30 days for pulling down the works you have undertaken. Now, once a notice is issued, that person should not proceed with the development works. And the law provides that if you don't comply with a request made in a notice, it is a contravention, it is an offense, and if works continue, the local authority may seek an injunction from the Supreme Court, but these happen in rare cases because for a local authority to seek an injunction, it is costly and the outcome is uncertain. You may obtain the injunction or you may not obtain. Now, as conclusion, I would like to say that local authorities have been given sufficient powers and authority to deal with the development control function. And what is authorized on land contributes to a large extent to the quality of the built environment. The influence that planners can exert is great on this quality on the development control function. And where this influence is inappropriately used, it can do a lot of greater damage. Therefore, architects and planners have a major role to play in the process. So far, this is my personal view. There have been very little collaboration I mean, in a more formal manner between these two professions. One way forward would be to think on how to achieve a better collaboration. This is my end of my presentation. Thank you.
Okay, thank you, Mr. Pearl. Thank you very much indeed for, again, so just making sure we stop sharing the screen there. And just give me a few seconds before I can do that. Thank you very much indeed. If I can have so we've got about 20 minutes to get some of the question answer. We'll be looking at finishing at 8:30. So we've got a few questions there which we'd like to take. And can I also please ask that if you can want to submit your question, please do now. We will stop taking question in 2 minutes at 8:05 because obviously there'll be too many questions. So I think most of the question has been sent. So please, if you can, let's try to answer as much as we can. Mr. Pearl, thank you very much indeed. And can we have a big round of applause for Mr. Pearl, please, with your little emoji for her wisdom, for his wisdom, for his knowledge as well. Fantastic to have that today. So thank you, thank you. Just quickly then, in terms of Mr. Pearl, there's a question from a colleague architect. He says the NEL doesn't cater for clearances from CB, CWA, WMA, and other authorities, including Ministry of Environment. What's your thought on that?
It does cater for CB, CWA, and WMA. If one is submitting an application while filling the form, he has to come across that section where he will be required to fill in certain questions related to these 3 public utilities. Okay, so there is an option there. There's a section, right? Yes. Okay, thank you. There's an anonymous attendee. What happened if the authority said amendment of we've talked about the 8 days, that's fine. There's a question for Mr. Mutana. Who is considered the principal agent? So we talk about the clearance certificate, or so who's considered the principal agent?
It's normally the consultant who is responsible for the project. So most of the time it's either the architect or the engineer, depending on the type of project. I mentioned it earlier. Yeah. Okay. But most of the time it's the architect. I normally sign as. It's 99% is the architect, right? Okay. By building project, yes. Quickly then, there's a question in terms of, I think we answered that, but correct me if I'm wrong, everyone. Question from Alvin. BLUP requires notification both on the referred site and in newspaper. People may object within 15 days from notification. Does the law BLUP guide requires that application can only be made 15 days post the notification in place? I don't know if you've got that. So I'll repeat again. BLUP requires notification both on the referred site and in newspapers. People may object within 15 days from notification. Does the law BLUP guide require that application can only be made 15 days post the notification in place? If I start with Mr. Pearl. Yes. Yes. You can submit your application only after the 15-day period for making objection has lapsed. The reason is simple. You cannot submit an application on day 1 and of the 15-day period, and the council receives objections and cannot sort out that objections. Okay, thank you. Question for Ramjit, really. Does a residence require an occupation certificate if it's above 150 meters square? Does a residence?
Yeah, of course, above 150 it requires, as my colleague was saying previously. Unfortunately, it is not the project architect who will do it. The client may seek the help of another architect for the clearance certificate. But according to me, it shall be the design architect, the one who has been supervising the work as well as designing the project. It shall be the person.
Okay.
I want to give
Just-
an example on this, Anil. There are clients who hire. It's very rare, but there are clients who hire the services of an architect just to get their plans approved, and then they do the works themselves. They find somebody else to supervise the works. It could be an engineer, it could be a friend, and then at the end of the project, they will find an architect who will come and issue the compliance certificate. For
That's
us, registered architects, this is not a good practice. We would not encourage this. But like Raj just mentioned, this type of practice should not be authorized. I think the PAC should look into this. An architect should be responsible for his project from start to finish.
Yeah.
When you're doing your design project, you should make sure, because you will be responsible for the project for 10 years, you're giving a 10-year professional indemnity on this project. So it's always good to do the work from start to finish, from design to supervision. Yeah, that's how it should be. Thank you.
Okay. Just a quick question then for Mr. Phul. Does all people, I think this is just a general question, I think, does all people working in the planning department are well-trained planners?
In a planning department of a local authority, there are only two planners, the head and the assistant, but they're supported by a team of inspectors.
Okay, thank you.
Inspectors and assistant inspectors.
Okay, thank you. And Mr. Sinod, in terms of town and country planning, again, are they all trained to be able to advise on town and country planning?
It is good to know that even the inspectors, they are qualified planners. They may not be appointed as planners. They already hold the qualifications as planners. So they are well better equipped with the knowledge as a tool, with the knowledge in planning as a tool. Even other ministry also, the assistants, those who are assisting the planners, they are already qualified planners. It's a good thing that the University of Mauritius has set up this course of town and country planning. And many people in their profession, maybe they were not qualified as planners, they were inspectors and assistants and so on. Now so it's a very good thing that they are working, and at the same time they are following the course, they are getting hands-on practice, and when they end up with a degree, they already have the experience. This is a very good point. Good thing.
Okay, thank you very much. Mr. Phul, there's a question from Michel. It's in French, of course, the question, but what he's saying is that many architects prefer to go through the OPP, which is the outline planning permission. Does that mean the regulation are not clear enough for them not to go through OPP? That's the first one. And what's your thoughts?
Usually OPP is meant for a project that might be complicated, or a site where you are not sure whether you might get an authorization. You're not certain about it. So OPP is not rare, but something which you use just to get an accord de principe. Let's say, for example, you have got a site which is just outside limits. You want to do a residential development. You want to have an assurance that a residential development will be allowed there. That's all. But then there are a lot of reserve matters, the number of floors, plot coverage, etc., that will be taken care of at the BLUP stage. It's just an accord de principe on the type of development you want to take on a specific plot.
Okay, thank you very much indeed. There's another question. This is from Nick. For BLUP, is it appropriate for the architect to be the applicant, or should it be another party? Maybe Mr. Mutana, you can touch on that. For BLUP, is it appropriate for the architect to be the applicant, or should be another party?
I think it's if the architect is the applicant, when there would be additional information that would be required, it would be done very quickly. Otherwise, you have to get the information from the applicant and then send it back to the applicant to get the the necessary information. But if it's done by the architect himself, it will go faster. He can also phone the planner and discuss also, prior to sending the information.
Okay, there's a question for Raj. This is coming from Alain. Pour quelles raisons les bâtiments existants anciens ne font pas l'objet de protection particulière pour les autorités? L'île Maurice ne se soucie-t-elle pas de la protection de son patrimoine? So Alain's talking about listed building. Why are they not protected enough by local authorities?
Yeah, listed building. The government has started to do the restoration of several old buildings. I personally am doing the slavery museum. I've just done la Tokenique, Pointe du Diable, La Voie at Maïbou, also L'Abreuvoir. We are doing the art gallery next to l'hôpital militaire near Appadoo. I think that we can't do everything. Like in France, for example, or other countries, the private sector invests in restoration, like the banks who get so much money on our interest, on loans, all that. They help the country to finance the restoration. And actually, it is a lot of fun in Mauritius, which is ils sont en train de donner de l'argent, une partie 50 millions chaque année, afin de pouvoir restaurer certains bâtiments. But still, 50 million is not sufficient per year. Yet some restoration have been done. And I've asked the question once to a minister, and he told me, would you build a school or restore a building? The question was tricky, you know. Est-ce qu'on construit une école de plus, ou on rénove une école, ou on va restaurer un ancien bâtiment? Bon, c'est notre patrimoine. Il est important de garder la tradition, de faire revivre cette tradition. We all architects must maybe have a brainstorming session on buildings that shall be restored. Voilà, Annie.
Okay, thank you very much for this clear explanation. There's a question from Mark. Mr. Phul, will authorities accept payment for a silent agreement?
It's in the law, they have to accept.
They have to accept. All right, so that's a straightforward answer. Just quickly then, the other one is, please clarify in which cases are a demolition permit required?
I gave a definition of development works, and in that definition, there is demolition. So if you're demolishing a building, you require a permit from the local authority.
Okay, you talk about, I think I want to just share that quickly as well here. And you talk about this here, where you've defined in the local act where erection, extension, or demolition, right?
Yes.
Okay, fantastic. Thank you very much. We've got a question, really. This is a tricky one. Maybe I can ask Mr. Mutan on this one. The BLUP document for building exceeding 150 meters square floor area, if all drawing ought to be designed and signed by an registered architect, does that mean if an extension of 50 meters square is being done to an existing house of 120 meters square, the total house will be 170? That extension require a registered architect to design and sign? Question mark. So you're doing a small extension to an existing house. Do you take all the entire amount together?
It's a very interesting question. I would like Mr. Phul to answer first, and then we'll discuss further.
Okay, so small extension, what do we do?
Can you repeat the question, please?
So the question is, we've got an existing house of 120 meters square, and you're adding an extension of 50 meters square. The total become 170. Do you still need an architect, or can the individual does it?
I had that issue I sought advice from the Professional Architects Council, and the Professional Architects Council replied that if at the end the building becomes 170 with the existing part, you still require an architect signature.
Wow. Okay. So that's. Do you agree with that, Mutana and Ranjit?
Indeed, indeed, yes.
Yeah, I agree.
Okay.
Of course, because 20 square meters can be also 100 square meters. When you have a ground floor house, you're having a first floor over the ground floor. It's quite a lot of square meters.
Okay, so we've got 10 minutes, 5 to 10 minutes left. Quickly, Mr. Sinha, just a quick one. There was an anonymous attendee. He or she says, what to do when clearance from forestry, for example, is taking too long. So if any authorities are taking too long, from your experience, what do you do?
You have no choice than to battle with the authority. For instance, where I'm working, we are waiting for a land conversion clearance for more than 1 year, and the BLUP application, and it's for community development. The ENL Foundation wants to construct a community building within the small city area, and we need a land conversion clearance. The land conversion clearance is pending for more than 1 year, and the local authority has kept on hold our BLUP application, just waiting for this clearance. So we are helpless, we can't do anything. We just have to battle with the authorities, keep on trying to get the officer to see where, and the procedures are lengthy at times. You see the administrative system in ministries. I've come from a ministry, and I know you have technical ministries where technical things, you submit an application at the ministry for a clearance. The application itself may take 10 days before it reaches the desk officer. It has to go to the permanent secretary and to the registry system. It goes through all ways before it reaches the officer who how to work on it. Now the officer, now with the COVID pandemic, you have many ministries where the officers are either in isolation, they're not working. So it's very difficult.
Okay.
I'm just battling with the authorities to get the relevant clearances.
Okay. When you say battle, what do you mean? Do you write to them? Do you talk to them?
Write to them. Okay, in the first instance, we write to them, but we can't just keep on writing. Your letter will go in the drawer. We try to contact the officer on phone to see, and try to find an appointment for a meeting to discuss our problem.
No, I think it is important to know that, because many students are watching us as well. It's good to know the procedure. Mr. Mutana, you want to say something?
Yeah, I just want to give Mr. Sinet some good tips, how to get these things faster. I think the first thing first, when you know that you would need a clearance from the forestry, either the municipality or the forestry department will inform you first whether they will be making a site visit. So the best thing to do is be there when they site visit and answer all the questions that they ask you. So once all these things have been clear, I can guarantee you that you will get your clearance as fast as possible. And it is with this gentleman that comes on site that you can sort out everything.
Thank you.
This is the best part. And then when he goes back to his office, you keep contact with him, you phone him, and he will tell you exactly where is the file and what is to be done. And I can assure you, within 10-15 days, you will get your clearance. This is how it's done.
Okay. I've got, thank you, Mr. Mutana. Just quickly, Mr. Phul, there's a question. Will there be a complaint desk for the BLUP one day?
There is a help desk which is supposed to be operating in all local authorities. A help desk, plus all local authorities, they have got what we call a citizen support unit portal where any sort of complaints can be made.
Okay, thank you. There's a question from Chris. Sorry, could Mr. Phul clarify the 150 meter square limit for non-architect? Does an architect really need to submit the BLUP if it's over 150 meter square?
as far as I know, there was that requirement previously for applications of 150 meters square and above to be submitted online by the architect drawing up the plan. But when all applications became mandatory for all applications to be submitted online, I think that requirement was removed, but I'll have to check.
Okay.
It has been removed.
Mike.
It has been removed because I know the client, even the client, they themselves, they are doing they are uploading everything online. For
It's
the
true.
fund.
We are doing
Yeah.
it. Yeah.
Which is not a good thing, which is not a good thing, I personally think.
Okay, I've got 3 key questions. I've got a question from Ashwin. Can we have an outline map for the civil aviation clearance for the context ground only or ground plus 1 building in the Southern Territories?
This map is in the outline planning scheme for the Kaur District Council. The outline planning scheme is a public document and it's available to anybody who wants to consult it at the District Council or the Town and Country Planning Board.
Okay, thank you. There's a question from Kailash. Upon any objection by the local authorities based on additional information or clearances required, the local authority should back their request by stating specific law and regulation. Otherwise, it is deemed void. What does Mr. Phul think about this?
I think I did answer to that. Whenever you're requesting for modification, it has to be factual. If you are requesting for modification to the plans, you have to state the reasons why you're requesting these modifications, and it has to be according to plans policies and factual errors on your plans, on your documents.
Mr. Watana, what's your thoughts on that?
Excuse me, can you repeat the question?
So the question is, if upon any objection by the local authorities based on additional information or clearances required, the local authority should back their request by stating specific laws and regulation. Otherwise, it is deemed void. Your experience?
Yeah, but most probably it will be a reply from the chief planner of the district council or of the municipality. He will mention exactly what has to be changed in the drawing. So I don't find any problem with that. It will be mostly planning issues, so which we architects would understand.
And Mr. Sinha, yeah.
The planning guidelines, yeah.
Mr. Ramjit, what's your experience on this one again in terms of specific?
Yeah, Mr. Mutana is right. You have even the name of the officer who is working on your file, and you can contact this officer. I've been contacting, and I received all the information I needed, and this is a very good way of doing things to facilitate our life in requesting a BLUP. Yeah.
Okay. Thank you very much indeed. Last question really before we conclude. I've got 2 slides to conclude. The question goes on to Mr. Phul, and maybe we can touch with Mr. Sinha on this one. How many pull-down notices are served each year in Mauritius? And who are the concerned people to ensure that the pull-down operation is being correctly carried out? So in terms of statistic, anything, Mr. Phul?
I don't have this sort of information because, and it is the responsibility of the local authority to ensure that the pulling down. But I'd like to give you a case study. A pulling down is always difficult. While I was working in a local authority, a very famous company put up something very ugly in a very prominent space. The council did take action. the case was sent to the district court. The district court ordered the pulling down. Then the guy made an appeal. It went to Supreme Court. The Supreme Court returned the case to the district court, and it went on for about 8 years. When eventually we could pull down the building, then we have to seek an eviction order so as to get all the things out. And it was not as that easy, and the building is still there today, and it has been added upon.
Wow.
It is
All
very
right.
difficult.
Okay, so I've got a thank you, everyone. I've got lost. I want to show you one slide in the video before we conclude on a 2-hour CPD. We've got 3 minutes to go. So I want to just share my slide quickly with you before we conclude on this amazing webinar. Of course, please provide your feedback as well as we go through. I just want to make sure I've got my screen shared. Here we go. So just taking time to get through. Just give me 1 minute. There we go. So thank you, Mr. Nana, Mr. Raj, and Mr. Ramdas for this awesome session today. So just quickly, I want to just show you a quick video which was published 2 weeks ago on the RIBA Sterling Prize Shortlist 2021. So I'm just going to share this video with you before we conclude. Here we go. So if you can hear the sound, please, and the images, please, if you can put your hand, give me a hands up on the emoji. Thank you.
People might look at this building and think, oh.
What we've tried to do is bring together the Islamic and British traditions to create something unique for this site, this client, and this brief.
Some of the success of what the team has achieved here is a building that is simultaneously foreground and background.
The building is intentionally a very atmospheric visitor experience.
People might look at this building and think, oh, it's completely modern and contemporary, I've never seen anything like it. But actually the building methodology is as old as the megalithic architects, builders.
For me, the one word that epitomizes this building is open. It's very important to our students that they feel that this building is here for them and they can move into it and occupy it and use it the way that they want to.
We created a place that has a real sense of community and where the residents can feel they belong to.
When we proposed it to English Heritage, I never thought they'd accept. But sometimes the crazy ideas are actually the best ideas.
Okay, so that will be in actually 2 weeks' time where the winner will be revealed. So watch the space on that one. And before we conclude, just quickly again, the Zoom does take a little bit of time. And so to conclude, thank you, Mr. Phul, so from the bottom of our heart and on behalf of all participants today, endless thanks for your invaluable time and giving back to us. Hugely appreciated for this amazing, thought-provoking and informative webinar. And also thank to our panelists today, Mr. Nalla, Mr. Raj, and Mr. Ramdas. Thank you very much indeed. I've got a final question, which I'll share. And of course, the next CPD by the PAC MAA would be a contract in the construction industry. Very important there as well. Take care, be safe. And of course, we get back there. So just a final word of wisdom before we take on. So I just want to share the poll quickly. And the poll here is, did you find the webinar useful today? And would you like similar collaboration talk? So again, be honest, I think I found it really useful today. Of course, please let us know what your thoughts are, whether you'd like more of those, and did you find it useful today? So just quickly then, while the participants are voting, I'll start with Mr. Sinod for your final word on, are we as a country moving to the right direction in assisting and making seamless progression?
Of course, yes, we are moving in the right direction. And I would like to make an appeal to all professionals, whether planners, engineers, surveyors, and architects. So our professionals, we are assisted by our technical people. But much of the groundwork is done by the technical people. But at the end of the day, we put our signature. So it's a humble request whenever we put our signature on any document, any project or plan, we must ensure that the product is good. Okay, all the issues have been taken on, dimension and so on are correct. Because at times it's if anything goes wrong, it's not properly put on the plans and even documents. So when they are uploaded, they are screened by the local authorities. After that experience, they screen very well. They screen thoroughly all documents. And whenever anything is missing, it goes back to the process that the system is sent back to you. You have to amend and so on and resubmit. So it takes time. So these are my final words.
Okay, thank you, Mr. Sunassee. Thank you very much on behalf of everybody. Moving on to Raj Ramjit. What's your word of wisdom to all the architects watching you today? And how do we collaborate going forward with Mr. Phul and his team?
Once again, we have experience together that our job is not limited to designing. It's not limited. An architect, he is not here only to design. We must know all these procedures, the Town and Country Planning Act, the Building Control Act, the Local Government Act. These 3 acts are important to all architects. Designing is one thing and knowing the procedures is another thing, and it's important. Here it is, Anil. Thank you.
Thank you, Mr. Mutana. Thank you, Raj Ramjit. Mr. Mutana, of course, you're a prominent figure on many building codes as well, and your rich experiences. What is your final word of wisdom today based on the amazing presentation by Mr. Phul?
Well, first of all, thank you for having me as your panelist. It's been a pleasure to be here, listening to Mr. Phul expose. He stressed about this Local Government Amendment Act of 2018. I think we as architects, we are very much responsible of how buildings are being designed, how buildings are being built. And this Local Government Amendment Act of 2018 stresses on illegal construction. So as architects, we are also responsible to advise our client to build as per approved plans. And as long as we stress on this, I don't think there will be so many change in the design. Obviously, there are changes as per the request even while you're building, but you should always bear in mind that whatever has been approved, you have to make sure that you are doing the construction as per the approved drawings. Yeah, thank you.
Okay, thank you very much, Mr. Mutana, for all your wisdom and guidance. Before I complete with Mr. Phul, Kailash, town planners and architects should collaborate. Thumbs up to Mr. Phul. Thank you very much. And we got Michel from France. Merci à tous. In terms of percentage, Mr. Phul, what do you think the poll would say? Where I said, did you find the webinar useful? I mean, your guess, what would you? What's your? I know your statistics aren't very good, but what do you say?
No idea.
Okay, so I want to share the poll with you. So 98% love the presentation, right? And they want more. And only 1%, one person, which is equate to 2%, has said no. And that person, maybe he or she is hungry, and probably they are obviously it's dinner time, and it's always dangerous to between a webinar and the dinner. So can we have a big round of applause for Mr. Phul, please, for 98% today, for the fantastic achievement for the webinar today. Finally, Mr. Phul, what would you like to say to the architect watching you today? I mean, I know you guys are, of course, working on it and making sure the process and processes are always seamless, because I'm sure it makes your life easier as well. So what would be your word of wisdom, and what would you like to see in the future working closely and collaboratively with the architects?
We should like to leave a legacy that we will be proud of. So this is one way forward, because what we are doing shape up the environment. So we should shape up the environment, and we should leave an environment that our children and grandchildren will be proud of and will not blame us for leaving things that are ugly and unacceptable.
Okay.
We should continue the effort.
And in terms of the procedures, I'm sure you're working, I mean, just a word of advice to all of us, I'm sure you're working behind the scene to ensure that the process of BLUP keep improving, right?
Exactly, like I told you, only this morning there was a working session the Minister of Local Government had with all the chief executives and the head planners of the local authorities. We stress that there is need for improvement, there's need to give more people public satisfaction, and we should be more transparent on the way we do things.
All right, fantastic. So again, once again, thank you very much indeed. Please do send me your feedback on an email and also your name for the certificate attendance. Mr. Phul, again, thanks a million. Mr. Sinod, thanks a million. Mr. Mutana and Mr. Ramjit, thank you for your time on a Thursday evening when we normally have Bollywood movies starting on a Thursday evening. So thank you very much indeed, everyone. Take care, and we'll see you when we see you. Thank you very much. And a big wave maybe from the panel, from everyone here, please. And Mr. Mrs. Appadoo as well. So a big wave from the panelists. Thank you very much indeed, and take care. We'll see you in about a few months. Thank you. Take care. Bye.
Thank you. Bye.